Okay, so we will go ahead and get started with our webinar for tonight. I'm Catherine Davis from the Indiana Resource Center for Autism, and I'm going to be the moderator tonight. We have some of my colleagues as well in the background who may be helping in the chat. Tonight's webinar, our topic is special needs trusts, and our speakers are Gordon Holmes, financial advisor and special care planner, and Liz Holmes, special needs attorney. They have a wealth of information for us tonight. Before we get started, I just want to let you know that the webinar is being recorded and will be posted on our website and on Facebook for you to watch later. Your microphones are muted. We will have them talk for about 30 to 45 minutes, and you are not able to type in the chat, but if you want to ask a question, if you just scroll to the bottom of your screen and click the Q&A, and you can type it in there, then they will answer questions from the Q&A box. Okay, so now over to Gordon and Liz. We're going to get started.
Wonderful. Good evening, everyone, and thanks so much for joining us. This evening's workshop will include an exhaustive review of the different types of special needs trusts and how these important tools can be helpful in planning for the future of our family members that have special needs. I think you'll find it both informative and interesting. Hopefully, some material you've not seen before. We have the PowerPoint up, and we'll be proceeding with that. Again, we invite you to ask questions. Please don't wait to the end. Just go to the question and answer area and enter them. And Liz and I will attempt to answer the questions as they come in so that we don't lose anyone at the very tail end. I do want to mention that as a part of participating in the Indiana Resource Center for Autism's series, we're pleased to provide to you a free follow-up consultation. I did say free. There's absolutely no cost to you whatsoever. And to take advantage of that, you will have contact information at the conclusion of the workshop. And it's as easy as just sending an email or giving our office a call, and we will get you plugged in for a free consultation to see how all of what we have covered this evening and in our other sessions applies to you and your situation. Again, please keep that in mind. Here we go.
Just a point of clarification, you said our office. We are two different offices. I have my own law firm. My dad works for Mass Mutual. Most of the time when we do co-presentations together, people reach out to my dad's office first. That's not to say you're not able or welcome to reach out to my office, but I just want to make the point that we are two different offices.
Okay, and speaking of that, we go next into disclosures. I am indicated associated with Mass Mutual. Mass Mutual is who sponsors the Special Care Program, which is a nationwide network of highly trained special needs advisors like myself. It just so happens that my focus is primarily here in the state of Indiana, although I do have an office in Louisville as well. The 10 steps to comprehensive life care planning, as you can see there, to address primary issues, create a life care vision, guardianship, which we covered in session number 2, identifying financial resources. Financial resources can be a great help with special needs planning. At the same time, without careful planning, actually resources can cause problems. I was on the phone and in Zoom meetings today with 2 or 3 families with resource issues where government benefits are being canceled, so to speak, or removed, and periods of ineligibility with Social Security are a problem, and so forth. So government benefits, which we covered in session number 1, are complicated. And if any of you missed session 1, I would encourage you to check the Indiana Resource Center for Autism's website, and because session 1 is amazing. We go into SSI, SSDI, Medicaid, Medicare, and also Medicaid waivers and so forth. So a wealth of information in session number 1. And by the way, this series that we've done for these 3 sessions covering government benefits, ABLE accounts, guardianship, and special needs trusts, those are 4 workshops out of a library of roughly a dozen workshops. And so there are other topics that we can touch on in addition to revisiting information we covered in this series, as well as updates to it. So if you have an interest in more workshops, more education, more information, then do feel free to reach out to the Indiana Resource Center for Autism and let them know that, so that we can work together on future programming. Preparing life care plan costs, preparing a letter of intent. Letter of intent is the caregiver guide. We talk about that during the free consultation. We have a template to assist you in building that owner's manual, so to speak, or caregiver guide for your loved one with special needs. Prepare legal instruments. And we'll touch briefly on some of those documents this evening, though the majority of our time will be spent on trusts. And then review the need for special needs trusts again tonight, and also ABLE accounts, which we covered in session number 2. Session 2, again, primarily guardianship and ABLE accounts. And so if you missed session 2, again, encourage you to go back and pick up on that. We went much deeper into ABLE accounts than is often the case or has previously been the case, and also guardianship as well. I think you'll really enjoy that. The importance of family and having a family meeting to draw everyone in so that everyone's on the same page. And then, of course, the need to review. Okay, some reasons to create a special needs trust. Developmental disabilities. And it seems like a great number of individuals with special needs these days, there's a focus on the developmental disabilities. That's what the Bureau of Developmental Disability offices statewide focus on. That's what the Family Supports Medicaid waiver focuses on, and so much focused again on developmental disabilities, congenital disabilities, that is disabilities that have come from birth, which many of the syndromes, Down syndrome and other syndromes and conditions occur as a result of birth. Traumatic brain injury and or spinal cord injury. These are through auto accidents, through medical situations, but we see a fair number of individuals that have been affected by either medical procedures that did not go well or accidents, either from automobile, motorcycle, sports, snow skiing, just on and on it goes. The various things that we do for pleasure that sometimes end up in anything but pleasure. Medical malpractice, personal injury liability, situations where a person may be injured as a result of an accident. In recent months, Liz and I both have been working with a young man affected with a traumatic brain injury as a result of an auto accident at about the age of 12 or 13. And in fact, I had a family on the phone today that received a relatively small settlement of $13,000 as a result of injury sustained in an auto accident. And that's the case where Social Security is determined as a result of that small settlement. They actually now owe them over $20,000. So you get hurt in an accident, you get a settlement of $13,000, and when it's said and done, you owe Social Security over $20,000. And so the family clearly upset about the situation and was trying to find the equity or fairness in that. And so we're working through that with them. Manufacturer liability. Manufacturer liability can occur as a result of even a piece of furniture, such as a crib that malfunctions or collapses. It could be a child seat in a car that does not work correctly. It can be an automobile that has a switch that locks up and causes the vehicle to go out of control. There's so many manufacturer situations. Structured settlements that usually follow settlements as a result of medical malpractice, personal injury liability, or manufacturer liability. Inheritances, that is money that comes perhaps unexpectedly, again, can create resource issues. Receiving a gift. I got this gift, if not inheritance, I received a gift, and now it's going to undermine my continued eligibility for Medicaid, Medicaid waiver services, et cetera. And then Medicaid and or Social Security eligibility issues relating to income or resources. So lots of situations that call for special needs trusts. That's why it has, over the last 2 decades, become an essential tool in special needs planning. Okay, just a brief primer on government benefits. We have the insurance type, which are benefits that are focused on contributing to the system, such as paying Social Security taxes, et cetera. The primary benefits being Social Security disability, including adult child benefits for our family member with special needs, and Medicare benefits, and then needs-based benefits, the SSI and Medicaid. So SSDI provides a monthly financial benefit, and then Medicare for healthcare, very similar with SSI and Medicaid, a monthly benefit and healthcare. But they're different in terms of what it takes to qualify for them and also what it takes to maintain eligibility. But different types of special needs trusts can be very supportive to a person that's trying to, quote unquote, get on with their lives, but not in such a way that it robs them of the safety net or security provided by these important government benefits. So a few did you knows, and then Liz is going to kick in with the meat of the material this evening on the different types of special needs trusts. Individuals with special needs who may qualify for both Medicaid and SSI may not receive these government benefits if their assets exceed $2,000. So $2,000 is the resource limit for a single individual, $3,000 typically for married. And so there are resource limits to attend to. A strategy, place the assets, including inheritance, gifts, life insurance, et cetera, in a carefully drafted special needs trust. Special needs trust assets that supplement the needs of your dependent and will not jeopardize a beneficiary's eligibility for needs-based government benefits such as Medicaid, Medicaid waivers, and SSI. If properly established and administered within a certain trust arrangement. So in other words, if it's done right, what's in the trust doesn't count against them. And there's literally no limit as to how much a trust can hold. So powerful tools available to us for special needs planning. Special needs trusts provide financial oversight via a trustee, safety net, quality of care, focus on what government benefits can't or won't pay, and what the beneficiary is unable to generate on their own through perhaps part-time employment. You should work with an attorney that is familiar with special needs and creating special needs trusts. And so I'm pleased at this point to turn the presentation over to such a person as Liz, my daughter. And so Liz, help us out.
Absolutely. So my name is Liz. I'm a special needs estate planning and elder law attorney. One question posted here by an anonymous, say that 5 times fast, attendee. Is it possible to get the slides from the last webinar? I was unable to attend and did not receive an email. I think Catherine can help you out with that. So I'm going to say Catherine will help you out with that and say that I answered it live.
Yes, I can. That person could just email me. I'll put my email in the chat now and I'll get that figured out. Yeah.
And don't worry about being anonymous or otherwise, we don't judge here. So it's all good. There is a fairly recent law that was passed in 1993 called OBRA 93, which then brought into inception the first party special needs trust. So the Omnibus Budget Reconciliation Act was passed, and it really was one of the first opportunities to use a first party special needs trust. Third party special needs trust existed before, but first party was really brought in 1993. And when we say first party, just to take a moment for those that don't speak legalese geek like I do, first party and third party are the two types. And I know we'll get into third party in a minute, but I do want to take a moment so that you're not lost through this presentation. It all starts with whose funds was it to begin with? Was it your funds for your child, or was it your child or your adult with special needs money? If it was their money originally, like receiving a direct inheritance or that kind of thing, then that would be first party money and should go into a first party special needs trust. If, however, it's a parent's money or a loved one's money for that person with special needs, then it can go into a third party special needs trust. And Catherine, Dawn Baxter is saying she can't access the chat. So I'm going to let you answer
Sure,
that.
I'll reply now. Yeah.
Thank you. Okay. So the thing with OBRA 93 is it limits it limited people's ability to transfer assets while trying to qualify for Medicaid. With Medicaid, whether it's assets or it's income, assets are also known as resources. There are exceptions to the rule, but generally speaking, you have to be under certain thresholds to qualify for Medicaid. With the exceptions come first party special needs trust. So if you think of a special needs trust in general as a shield that can hold all sorts of things in it, the person can be on Medicaid on the outside. And this is a broad strokes, does not replace an initial consultation presentation, but I hope that my message is clear enough. Next slide. So a special needs trust is a means of enhancing an individual's quality of life. So Medicaid is more into subsistence. They're not into improving somebody's life. And so with that, things like a cell phone, a Netflix account, a Disney Plus account, I already mentioned a cell phone. Well, it got brought up again. There you go. Remodeling somebody's kitchen, getting an iPad. These are things the government does not think are essential, but many of us wouldn't know how to live a day without these things. It can be set up to send a dependent with special needs to camp, take vacations. Disney World is a common one, buy sporting equipment, pursuing education, all sorts of fun things. So I always suggest to trustees, and when I'm serving as trustee, that my first question will be, does Medicaid pay for that? Because why would you go to the store and buy Oreos without a coupon if you had a coupon in your car? So think of Medicaid as the coupon. And if Medicaid doesn't cover it, then we go further into the analysis. If we're talking about a first party special needs trust, namely somebody has come into money and we have to fix the situation, then it needs to be promptly, not just properly, but promptly drafted as well within the month received, so as not to affect public benefits. And then we do have the option to work with people like my dad to help invest and grow the funds as well. Next slide. So as far as who can establish a special needs trust, when the third party, other people's money for the person with special needs, anyone can do that. On a first party, a parent, grandparent, guardian, or the court, or now an individual can establish a first party special needs trust. So anybody who asks the questions, who will take care of them when I'm not around, or how can I pass on part of my estate instead of disinheriting, which was a thing before special needs trust became a thing, special needs trust can be a very viable tool to incorporate into your estate plan. You can establish a special needs trust with available resources. Now, oftentimes, before I go further and your eyes glaze over, I have a lot of clients that don't have a lot of money and offer payment plans as far as fees, but more, beyond that, they don't have a lot of money to leave their kid with special needs right now. And so the question comes up of, well, this all sounds great, but I don't have a ton. And my response to that is, well, it takes $2,000 to kick somebody off of Medicaid. And that doesn't take that much to get it, especially upon your death if you have life insurance or retirement asset or something like that. So Indiana is a dry trust state, meaning that you can leave it empty. You can set up the trust account and have nothing in it until you've died and fund it with life insurance or whatever other benefits. And a special needs trust is great in that you can leave as much as you want into it, and there are limitations depending on the facts at hand, but generally speaking, you can leave anything you want, as much as you want, and they can be on public benefits on the outside. And it can improve quality of life and direct final distributions beyond what happens if your loved one with special needs unfortunately passes away. Next slide. So a special needs trust works in that, I've already shared this, it operates as a shield. So anything that goes into the shield does not count. But the complicated part is that when you start distributing it from the shield, depending on for what reason and how much and what public benefits are at hand, will depend on the analysis. States are all different, and this comes up a lot in meetings. So Medicaid is a federal program, but state to state Medicaid is different. What is required in a trust in Indiana may be very different than California. California is much stricter on their fiduciaries, on their trustees, et cetera. Not to say Indiana doesn't take it seriously, it's just a different process. So state to state is different, and I can only advise in the state that I'm licensed in, which is Indiana, much like my dad in the states he's licensed in, it's very similar to that. You can name a trustee who's responsible to carry out the trust agreement. And if you remember that this is a team effort, you have a financial advisor, you have a CPA, and you have someone like myself who's not only familiar with trust laws, but also public benefit rules. It's not as daunting as it could be. We don't do what we do in islands. We work together. I can't be the financial advisor and the attorney. I feel like that's malpractice in a bag. Much like my dad cannot give legal advice or tax advice. It's the same thing. The trustee is obligated to act both in accordance with the provisions and in the interest of the beneficiary. So this is a really good point. There's a sole benefit rule in both of these types of trusts, whether it's a third or first party. Namely, the trust is being set up for the person with disabilities. It's not being set up for mom, regardless of how hard of a life mom has had because of whatever's happened to her child. It's supposed to be for the person with special needs. So there can be many pitfalls, and that's why having advisors along the way to ask your questions is really important. And there are many ways a special needs trust can be created. If you've heard of the ARC of Indiana, they're a great tool, and I think that's referenced on the next slide. Actually, the one after that, that's okay. There are several different types of special needs trusts. Their first party I've already referenced, so the person with special needs comes into money in one way or the other directly in their name. A first party special needs trust is also known as a self-settled special needs trust, very similar in title. The Special Needs Trust Fairness Act allows a person with disabilities, an individual themselves. They put in 2 words in the law, the individual, which allows a person with disabilities the ability to establish their own special needs trust, not handle it as in be trustee, but they can establish their own. So if somebody doesn't have a power of attorney, or somebody doesn't have a guardian or a parent or a grandparent available, Special Needs Trust Fairness Act really helped to close that gap. And then there's a third party special needs trust, which again is someone else's money for that person with disabilities. Special needs trust can be qualified disability trust as well. There is a tax exception. There's a tax exception, which will go on in another slide. And then there's a pooled special needs trust. So if you have $2,000, my dad has $1,000, and I have $500, my $500 is going to go a lot further if we invest and pool the money together. So the ARC of Indiana is a phenomenal resource and asset in Indiana, and they serve as trustee. And it's also very handy if you don't know where your loved one with special needs is going to be taken care of should something happen to you. I have a lot of clients, we both do, that they only have one person. And what if something happens to that one person? Or what if that one person doesn't want to deal with the loved one with special needs? It's too much for them. The ARC of Indiana is a phenomenal resource and super fun. If you would go back, please.
You've got a whole slide on Miller Trust.
Okay, go forward then. I can jump and jive with you. It's all good. A first party special needs trust. That was a flashback for you guys. I don't know. Jump and jive. It sounded fun to say. Okay. So a first party special needs trust, again, is typically set up with the monies that the person with disabilities has, whether that's through a settlement, a direct inheritance, that kind of thing. It can be established by a parent, grandparent, court-appointed guardian, court, or as I've already referenced, the person with disabilities themselves. They have to meet strict definitions of disability, meaning that they have to be under the age of 65 and they have to qualify as disabled. That does not mean that they have to be receiving Social Security benefits, but it does mean that they need to qualify under the definition of disability. And then for a first party special needs trust, there is a Medicaid payback clause, meaning that upon the person's death, if they've received Medicaid at any point in their life, Medicaid gets reimbursed to the extent that there are funds in the trust. And I've already referenced the sole benefit rule, but essentially that means that anybody who's disabled, if you're setting up a special needs trust for somebody with disabilities, it's for them. It's not for you. It's not for the family. It's not, for the neighbor down the street you hardly know. It's designed to supplement, not supplant. Supplant means that you're mindlessly distributing something and squashing public benefits. Supplant means that or supplement rather, means that you're adding to what public benefits provide. So there are several examples. I'm only going to pick a couple of them because I know that we're wanting to be mindful of your time, and we can certainly, add on after we're done if time allows, but we'll pick a couple of examples. So somebody who's receiving an unexpected inheritance, example 6 of $50,000. The analysis to go through that and ABLE accounts are a little bit out of the scope of our presentation today, but you should go back and look at that presentation we did on ABLE accounts because it's fascinating and fun. And we can also dive into it and bond over it more during an initial consultation. But an ABLE account can only hold up to $15,000 per year, assuming somebody qualifies, meaning that the onset of disability started at or before age 26. So assuming that ABLE accounts are not in the picture, for example, number 6, a first party special needs trust, assuming that it's a direct inheritance that was received, is the only option. And while yes, there's a Medicaid payback clause, if you've spent the money before the person dies, it's not really that big of a risk. And it's better that you can hold the money back, have it invested and grow, used for the person's lifetime versus squandering it and needing to spend it frivolously. So that's one example. Example 2, we'll go back up to there. Somebody who's age 32 has no government benefits. What if they have too many resources? The special needs trust can be a very good tool to use for sheltering resources, not income, but resources. So next slide. A third-party special needs trust, much like a first party, is dependent upon state law. While federal tax or trust law is a thing, Indiana, much like other states, have specific state laws. So this can be funded, a third-party trust can be funded and established by anyone of any age. A first-party special needs trust has to be under the age of 65. A grantor, the person granting the trust into existence, or settlor, same thing, can establish a revocable or irrevocable, standalone, otherwise known as an inter vivos special needs trust that can be funded at any time. Like I said, Indiana is a dry trust state, so you're not required to put dollars into it until you are ready. Whereas by contrary, or conversely, a first party special needs trust has to be irrevocable because if it's revocable, it's available to the beneficiary, and which would defeat the purpose because then they're not going to get Medicaid. And then at the beneficiary's death, there's no need to pay back Medicaid in a third party special needs trust. So that's an advantageous way to go. So you might be wondering, well, okay, if that's the case, there's no payback clause in the third party. Why would I ever set up a first party? Good question. Well, if you haven't done the right planning and you have a loved one that's died that's left money directly to your loved one with special needs, or you yourself did this, there's no other option at that point. If it's left directly to the person with special needs, we have to use a first party, which is great that we have a tool to use, not so great from the Medicaid payback perspective. A third party special needs trust does not provide for basic maintenance like food, clothing, and shelter. I will also add to that and say that the public benefits at hand that the person is receiving or could receive is a factor in the analysis for the person and the distribution of the trust. Next slide. The qualified disability trust, this is the exemption as opposed to exception that I was referencing earlier. So if a trust becomes a qualified disability trust, and you can see the requirements on this slide, then they are potentially open for this $4,300 exemption. Next slide. The trust must be a third party trust to be a qualified disability trust. It has to be funded entirely by somebody else. Again, consulting as a team is really important. I cannot do what my dad does. He cannot do what I do, and we both cannot give tax advice. So that's something to keep in mind. And somebody who is presuming that they can or telling you that they can, I would be very wary. Like, I don't give medical advice either, and I don't get it off of Google, generally speaking. The trust must be for the sole benefit of the disabled beneficiary. No other person can benefit. Now, I will give it one exception to this, and that is if you buy a fridge from the trust, other people can put their food in it. And you may be rolling your eyes at this of like, well, yeah, that's obvious, but it wasn't obvious to Social Security until it was recently put into their notes of their rules. This is the kind of fun that we get to deal with daily. The trust has to be established and funded before the person turns age 65. That is for a first party special needs trust. And then as most special needs trusts are funded with parents' assets, including life insurance, etc., it can make an even more valuable planning tool. So my family has 3 children. I should say my parents have 3 children. Myself, my sister, Emily, and my brother, Matthew. Matthew has special needs. So his third would go into a special needs trust as opposed to giving it to Matthew directly so he doesn't lose public benefits, as an example. Next slide. A pooled special needs trust. I think Catherine put a link into the ARC of Indiana. Wonderful people, super fun as well. If you're in Kentucky, Life Plans of Kentucky. If you're in Indiana, ARC of Indiana is the place to be if you want to look at a pooled special needs trust. Admittedly, that's not always the choice that my clients choose because they want to be in charge as long as they can because they feel they know their loved one best, but it is an appropriate option to at least consider. And then upon the death of the beneficiary, remaining assets they don't have to, but they can go to the nonprofit, to Medicaid, or to family, or to another organization. It depends on the situation at hand. The pooled trust serves as the trustee, and I should say the pooled trust serves as the trust. It's a nonprofit organization, and they serve as trustee as well. That line's a bit confusing. When you work with the ARC, they serve as trustee. You do not serve as trustee. One advantage of doing that is they will tell you yes or no when asking a public benefit question. But a disadvantage of working with the ARC is that they make the calls, you don't. So think about that when you're evaluating your options. And this trust can be less expensive. You know, that's kind of a funny comment, because the other day I referred somebody over to them that I thought would be a better fit because I thought it would be less expensive, and they quoted the same fee I quoted them. So that's not always the case, but it is fact sensitive. Next slide. A Miller Trust, I'm sorry, go ahead.
Let's see, 21, did you want to?
Oh, is that your slide? I'm sorry, go ahead.
It's okay, yeah. All right, so two questions that have come in. One has to do with a sibling situation. And the answer is, it's possible for a sibling to be the trustee on a third-party trust. It's possible for parents to establish the third-party trust for their son or daughter with special needs. And then the sister or sibling end up being the trustee of the special needs trust. Funds from the trust can be used for the trust beneficiary, and again, the sibling can be trustee. It's not a given that any trust is a special needs trust, though, and so I strongly encourage any plans you currently have be brought with you for the free consultation. There are many people that Liz and I have met with over the years that thought they had everything in place, but there were things that had not been considered, things that had changed, internal changes, external changes, this type of thing. And so part of the reason that we provide a free follow-up consultation is to enable people who have already done planning to have their plans reviewed to determine if everything is copacetic or if some additional planning or updating is indicated. So I strongly encourage even those on board that think they have everything done, I's dotted and T's crossed, please let us take a look at it. The time to determine that the plan does not muster up is not when something happens to you. And boy, the last 18 months have been a reminder to us of tomorrow is promised to no one. So strongly encourage that. The second question had to do with income. And so I'm answering these two questions or addressing them right now because the Miller Trust is all about income. But the question was specifically about $2,000. So the $2,000 limit is a resource limit, not an income limit. And it is possible under some circumstances for an individual with special needs or disability to actually have more than $2,000 a month in income. And we're going to talk about that momentarily. But as a general rule, the first of each calendar month, one's what's called available resources need to be reined in or brought down under the $2,000. This typically includes for a single individual with special needs or disability. It includes the representative payee account to which they may be receiving a Social Security benefit monthly. It can include an IRA, savings account, checking account, mutual fund, uniform transfer to minor act account, that is a UTMA, a custodial account. So there are lots of accounts that factor in or get are a part of the equation in determining whether the $2,000 resource has been exceeded. So suffice to say, if an individual, a consumer, is on means tested benefits, specifically SSI, Medicaid, Medicaid waiver services, and therefore, of course, Medicaid, you need to be under $2,000 at the start of each calendar month. Otherwise, you do potentially create what we call a period of ineligibility. And especially as it relates to Social Security, specifically the SSI, Social Security is known to go back years, literally go back years in checking bank records to determine periods of ineligibility. And this is how people end up owing $5, $10, $15, $20, $25,000 back to Social Security. And that's because the benefits kept coming, but due to exceeding the $2,000 resource limit, they actually were receiving those benefits during a period of ineligibility. I don't know if there is a run out on this time-wise, but again, I've seen Social Security literally go back years, create a debt, and then it may take years to pay off the debt under a payment plan or docking, so to speak, an ongoing Social Security benefit. So this is really serious stuff. And again, all the more reason to meet with a professional to have your situation reviewed. So with Miller, we're going back to over 93 that Liz was so kind to educate us on earlier, the Omnibus Budget Reconciliation Act of 93. And it brought about D4A, D4B, D4C, different types of special needs trusts, which is a substantial focus this evening. Well, one of the types of trust that is what I call the lesser known trust is a D4B trust, which is otherwise known as a Miller Trust or Qualified Income Trust. So when it comes to income, to segue from that second question that was posed, there are different income limits to be aware of, and the Miller Trust can help with income. That is the unique aspect of Miller Trust. Most of the other special needs trusts, the first party, the third party, the pool trusts, et cetera, that Liz has been covering, is primarily trusts to focus on resource or asset issues. Miller is specifically a type of trust to focus on income issues. So an irrevocable trust set up to receive monthly income in excess of the $2,382 allowed to maintain disability Medicaid and therefore Medicaid waiver services. And we're going to look at two examples here because there's nothing like examples to help paint the picture with this. But suffice to say, the $2,382 is the 2021 specifically, calendar year 2021 maximum monthly overall overarching income limit for an individual that is receiving Medicaid, Medicaid waiver benefits, this type of thing. If you go over 2382, unless you use a Miller Trust, that again, we'll show examples of momentarily, you're creating a period of ineligibility. You are literally, you run a risk of having the disability Medicaid pulled, the waiver services pulled, the budget with the waiver, and it doesn't matter whether the consumer receiving waiver services is at home or they're in supported living. They literally, by becoming ineligible, can become, believe it or not, private pay in supported living, or have to be returned home because the facility that's providing waiver services will no longer do it because Medicaid is no longer reimbursing. So these are issues that mistakes can be extremely costly, costly to the tune of hundreds of thousands of dollars. So example number one, Daniel has special needs and is employed earning $1,000 per month. Now I got to tell you, 23 years ago when I moved my practice in the direction of special needs, the thought of someone with special needs earning $1,000 a month would just be almost unheard of. So much has changed. So much has changed with folk rehab, supported employment, and wages for individuals with special needs. We're seeing now anywhere from $10 to $15 a month. And so it's much easier to get to $1,000 a month than had been the case in the past. So he receives $458 of SSDI, that's Social Security disability income, and $336 per month of SSI for a total monthly income of $1,794. So this is just adding 1,000 plus 458 plus 336. So here is someone just working part-time. Let's say as an example that he was earning $12.50 an hour. At $12.50 an hour, the $1,000 for the month is only 80 hours. So we're talking on average working less than 20 hours a week, again, less than 20 hours a week, and generating $1,000 per month in earned income. Added to the Social Security, now pushing up against $1,800 per month. Earned income is under the SGA limit of $1,310, which is the other key number from an income standpoint to be aware of. $1,310 for earned income, $2,382 for all sources of income. And then the $2,000 in resources. Those are the three most important numbers when it comes to Medicaid and Social Security. The $2,000 resource limit, the $2,382 overarching monthly income limit, and the $1,310 substantial gainful activity limit. So what happens when you exceed those? When you exceed the $2,000, you create ineligibility for SSI and Medicaid. When you exceed the overall income limit of $2,382, you lose eligibility for Medicaid and waiver services. And then at the $1,310, you lose eligibility not only for SSI, but also you can poison the well. which may undermine your ability to draw off of a parent's record in the future, which is in this very example we're going to talk about. So if you're going to go big, go big. But when you look at exceeding these limits, please understand that that you're tearing a hole through the financial and healthcare safety net provided by these government benefits. So in 2021, his dad retires. That is, Daniel's dad retires, making Daniel eligible for adult child benefits. Now, we talked about adult child benefits in the first session on government benefits, but please understand, if or when your child goes on SSI, most often at the age of 18, in most cases, they are only on SSI for some short number of years, and that is until a parent has a triggering event or their part-time wages makes them eligible to draw Social Security disability off of themselves, which Daniel was doing with the $458 per month above. Then they become eligible to draw SSDI, and they can draw off of themselves, they can draw off of a parent's benefit, and in many cases, SSI completely goes away. Now, in this case, his benefit increases to $1,500 a month. That is, believe it or not, off of his dad's record, he's drawing $1,500. So now his income dynamic has changed. The $1,500 now replaces the $458 and $336, but it's added to the $1,000 a month for his overall income. So at $1,500 plus the $1,000 a month in earned income, he's now at $2,500. He's exceeding the $2,382, which means if he has disability Medicaid and or Medicaid waiver services, he's at risk of losing them. He's only over by $108 per month, but this is not sliding scale. You hit $2,383, you're toast. So this could result in loss of Medicaid and waiver services. However, if a Miller Trust is set up to receive the excess, that is in this case, the $108, then Social Security sees him as staying under, or excuse me, Medicaid sees him as staying under the $2,382, and he can maintain his Medicaid, his disability Medicaid, his Medicaid waiver services, along with his Social Security benefits and his part-time employment. So literally, he can be taking in a total of $2,500 per month, still have Medicaid, Medicaid waiver services, and other potentially other government benefits as well. Powerful, really powerful. And we're seeing increased need for the Miller Trust as wages for our individuals with special needs are going up, and especially when they start drawing off of a parent's record and they're exceeding the $2,382 per month. Setting up a Miller Trust is not that expensive, and it can literally help preserve tens, if not hundreds of thousands of dollars of Medicaid benefits. Let's look at example number 2. Ted has special needs, and both parents die in an auto accident. He works part-time and earns $700 per month. His adult child benefits is $1,800. You can go higher under survivor benefits than you can under regular adult child benefits. So with only $700 a month and very part-time employment, he needs a Miller Trust to retain his Medicaid eligibility. Okay. Trustee responsibilities are covered. We're going to have to pick up the pace. We will finish by 7:30, but it looks like we may bleed slightly past 7:15. Does not look like any additional questions yet. So a family member can certainly be a part of the team. A trustee provides a critically important assistance. The tax returns can be completed by a CPA that the trustee employs. Investments can be handled by someone like myself that manages tens of millions of dollars of trust assets. And then, of course, you can have case management, social worker, medical individuals, et cetera, putting together a whole team. All right, methods to fund a special needs trust. Gifting. So if a grandparents or some other family member, godparent, or even family friend wants to make a gift, they can make a gift to the special needs trust. If you have a grandparent that says, I'm on for 50 bucks a month, not a problem. We can help that grandparent put $50 a month into that grandchild special needs trust. Retirement funds be the beneficiary. So if you have a 401k, an IRA, a Roth, a traditional IRA, et cetera, you can actually list the special needs trust as a beneficiary, and upon your passing, what's left in the retirement account can go to the special needs trust. I might add, with some special tax advantages provided by the Secure Act that was passed about 18 months ago. Investment account via transfer on death. So let's say a parent, grandparent, or aunt or uncle has a $10,000 mutual fund account. They can set it up to go to the special needs trust upon their death. CD, payable upon death. Also property. A special needs trust can hold a house, can hold land. There's almost no limit as to what a special needs trust can hold. Life insurance is a very useful and helpful tool for funding special needs trusts. And regardless of whether it's term, universal life, permanent second to die coverage, which is exceedingly popular in two-parent situations, lots of different life insurance options to help fund a special needs trust. The policy itself can be transferred into the trust if we want to get it out of the person's estate, or it can be simply funding the trust as by way of beneficiary. Okay, we'll move on from here. It's again going a revisit into government benefits, all kinds of things though on the right that a special needs trust can pay for. Basically on the left, healthcare and basic services. On the right is everything else. As I had a conversation with a grandmother some years ago, she said, well, the government's really helping out and paying for lots of things. What does the trust do? And I said, the trust is your grandson's everything else. So whether it's the Colts game, the Indianapolis 500, a NASCAR race, Netflix, cell phone, as Liz was saying, it goes on, a concert, you name it, vacations, travel, and so forth. It's the everything else. And frankly, you know, decades ago, we were stuck with just the government benefits because special needs trust did not exist. And individuals with special needs, frankly, did not live that long. But now that we are pouring into them, investing in them, and they're accomplishing so much and adding value and having and living meaningful lives that are in many cases supported by special needs trust, life expectancies are soaring. Additional services from a corporate or professional trustee. And I might mention that Liz does serve or provide trustee services on special needs trusts. Some attorneys don't, but she does. But nevertheless, this kind of walks through some of the services. We'll just move on in the interest of time. The role of a special needs planner like myself, we coordinate, we pull in allied professionals such as special needs attorneys like Liz. We have processes in place to make sure all the I's are dotted and T's are crossed. We run interference with government agencies on government benefits. There's a lot that's done on the planning side, but as Liz said, a teaming approach is what wins the day. Certainly a special needs attorney and special needs financial planner like myself working together takes the burden off, the pressure off the parents. And then again, also a CPA where appropriate in dealing with tax issues. Okay, well, 717, we actually did pretty well. And unlike the last workshop, I made certain that we had accurate and complete information from a contact standpoint. And Liz is appreciative of that. So on the left is special care and my information. As Liz said, usually the free consultation starts on my end, and then we progress with referral to Liz as we need to engage on the legal aspect of things. And it's as easy as simply calling the toll-free number, sending an email, that type of thing, or you can visit the website and request contact. So lots of ways to reach out to us, and it doesn't matter whether it's a guardianship issue or trust issue or wills or able accounts. We are delighted to assist and provide guidance with any and all, and then of course, as I indicated earlier, make appropriate referral to Liz for any and all legal issues. Okay, I see one thing in chat. Okay, and that's about the videos, okay, being posted with a link.
I think we're up to date with all of the questions, unless somebody
Excellent.
else has any others they'd like to ask.
Okay. Happy to stay on for a moment or two if anyone does want to enter a question into the Q&A area. I would be remiss if I did not thank the Indiana Resource Center for Autism, Kathy Pratt and her incredible team, Melissa Doobie and Catherine Davies and Amy Gaffney and all the wonderful people at the IRCA. It's such an honor to work with them for the great works that they do. And we look forward to returning in the future for more education. Also, I might mention that Liz and I enjoy co-presenting. And if you do work with any school or special needs co-op and feel the information that we've covered in this series would be helpful for the parents that are being served by the special education department, then do reach out to us. There's absolutely no cost in providing this. and we'd be delighted to either do a single workshop or a series for your school corporation or special needs co-op or a nonprofit. So please let us know. We're very passionate as a result of our personal journey at trying to help other families plan for the future.
Thank you so much, both of you, for helping us kind of figure out the path through this really complex topic. I'm sure people are going to think of questions afterwards. I would encourage you to contact Liz and Gordon and take advantage of their free consultation that they're offering with these workshops as well, because I know this topic is so detailed that you may need to discuss it with them one-on-one. As I said earlier, this will be recorded and posted on our website. It takes us a couple of weeks to get it up there because we have to close caption it, and that takes quite a while. You'll see all the other ones. The previous session of this is about to go up there this week, so it takes that long for it to go. And I've put the link in the chat where you can find that. We're also planning our webinars coming up for the fall. So keep looking on the website and you'll see those posted up there soon. But in the meantime, thanks for attending, and thank you to Liz and Gordon once again.
Take care.